What happens when a defense attorney crosses a line from zealous advocacy to outright intimidation? Today, we're diving into one of the most shocking courtroom confrontations I've ever seen, where Attorney Bennett threatened to destroy a prosecutor's career just for doing her job. This isn't your typical legal drama. This is real-life professional misconduct caught on camera. We're about to witness a judge absolutely demolish an attorney for trying to weaponize the grievance process. The stakes? A man's freedom, a prosecutor's career, and an attorney who's about to learn that threatening opposing counsel might just cost him his law license. Buckle up, because this courtroom is about to explode.
Back on the record in case of People's State of Michigan versus James Whitley.
No.
Typically, oh, go ahead.
Thank you. No full use on behalf of people.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett, appeared with now Mr. Whitley sitting to my right.
Typically, the court doesn't publicly discuss, and I will apologize, Ms. Hughes, and I will allow certainly counsel to say what they want to say or need to say. The court doesn't discuss bench conferences, but I think under these circumstances, I'm going to certainly disclose that, unless Ms. Hughes, since it was your issue that you brought to the court, unless you have some strong objection to that.
I have no objection. Thank you.
The court has been informed that, at least alleged, that the defense counsel has indicated that should this exam begin, that it may be his intent to grieve the elected prosecutor for pursuing this case.
Hold up. Did he just say what I think he said? For those unfamiliar with legal terminology, grieving means filing a formal complaint against an attorney that could result in suspension or even disbarment. Bennett literally threatened to end the prosecutor's career if she dared to proceed with this case. This isn't just unprofessional. It's a blatant attempt at obstruction of justice. The judge is about to explain why this is such a massive violation. But let me be clear. Threatening opposing counsel with professional complaints to stop them from doing their job is one of the most serious ethical violations an attorney can commit. Watch how quickly the judge shuts this down.
Case. Court has some concerns with that. First and foremost, that posture in and of itself can have a chilling effect, not only on just proceedings, and may be an attempt to interfere in these proceedings, which may in and of itself constitute a grievable offense, but also that this court, if that is indeed the allegation, would not proceed with a hearing that would require someone to then commit a grievable offense. And Ms. Hughes also disclosed to the court that she, in essence, went up her chain of command to seek their advice as to what she should do. It was ultimately said, I think, at one point to certainly bring it to the court's attention, which I think is appropriate since it's under. Mr. Bennett, I will ask you whether or not you believe, in this case, that the people in proceeding are committing a grievable offense. And if so, for you to state on the record what that offense is.
My concern.
I'm not asking for your concern. I'm asking for you have made an accusation that know what?
I don't believe that they're committing a grievable offense.
Do you believe that in starting this exam that they would be committing a grievable offense?
No.
Was that said to the prosecutor?
That was said, I don't believe it was said in the manner that was described at the bench, but certainly.
Then tell me how it was said.
Well, there were two things. One, at the bench, do you want me to ignore the one you didn't disclose?
Tell me how it was said.
What I said is that I believe that if the state were to go forward, that it would be grievable because I believe that the prosecutor is not following through on their ethical obligations under the Michigan Rules of Professional Conduct.
Notice how Bennett's story is already changing? First he denies it, then admits it, but claims it wasn't meant the way it was taken. Now he's trying to justify his threat by claiming the prosecutor isn't following ethical obligations. This is classic deflection. When caught red-handed, accuse the other side of wrongdoing. But here's the kicker. Prosecutors have broad discretion in pursuing cases, and disagreeing with their strategy isn't ground for an ethics complaint. Bennett is grasping at straws, and the judge is not buying it. Pay attention to how he keeps shifting his reasoning. This is what panic looks like in a courtroom.
Which ethical obligation are they not following for?
The two that I am concerned about are, one is determining what the actual facts are, and the two is prosecuting somebody who may in fact be actually innocent. What I did was I had offered Ms. Hughes, if she felt that it was appropriate, she wanted to discuss the recanted note with the alleged victim. I said, why don't we could just adjourn this out and you can talk to her and decide how to go forward. So my only concern is that they didn't make contact with the alleged victim, who now has a different story behind.
Wait, what? The alleged victim recanted their statement? This is huge. In domestic violence cases, victim recantation is unfortunately common, sometimes due to fear, financial dependence, or reconciliation with the abuser. But here's what Bennett doesn't understand. Prosecutors can and often do proceed with cases even when victims recant, especially if there's other evidence like witness testimony or physical evidence. The fact that Bennett is using this as justification for his threat shows he either doesn't understand prosecutorial discretion or he's desperately trying to find any excuse for his misconduct. Let's see how this excuse holds up.
Story, but I no longer believe that's a problem.
Is that, even as you describe it, amount to something that is grievable?
It doesn't.
And why was it said?
Because at the time I believed that it was grievous.
What changed?
Quite honestly, what changed is I wasn't aware at the time that they had the lay witness here. And so the presence of the lay witnesses, I think, eliminates all of the issues I had with the police providing the testimony.
Did you catch that? Bennett just admitted his entire threat was baseless. He's saying that because there's a lay witness present, suddenly all his ethical concerns disappeared. This is absolutely damning. He's essentially confessing that he made a career-threatening accusation without even knowing the full facts of the prosecution's case. Imagine threatening to destroy someone's career and then saying, "Oh, wait, never mind. I didn't realize you had actual evidence." This is why attorneys are required to investigate before making accusations. The judge is about to absolutely eviscerate him for this, and honestly, he deserves every word of it.
Testimony that's admissible here, but not in trial.
Ms. Hughes.
I absolutely intend on proceeding pursuant to MCL 76827C. I have made no statements to Mr. Bennett about Ms. Potter being present. But I don't think it is, because Ms. Potter is not present.
Explain to me, Mr. Bennett, how that makes a difference. Because quite frankly, I think your accusation is against the prosecutor. amounts to your attempt to obstruct these proceedings. So explain to me, which in and of itself would be grievable, counsel. So explain to me what happened now that you know that they're there, how that changed the whole mindset.
The proceeding with statements that would exclusively be inadmissible at trial and going forward on those. These are confrontation clause issues.
There's a statute which covers that.
I understand that, Your Honor. My concern was it goes to circuit court on those statements, and now they can't proceed to trial. Because at that point, confrontation is going to attach at trial.
So why would that be grievable? If they proceed pursuant to a statute promulgated in the state, as well as a court rule, which covers that, why would that be grievable at any point?
My concern was not determining the facts of the case that they're going to present evidence in tonight.
If they believe those facts that, but for a hearsay objection, would come in, that not at all goes to their determination of the facts. They may believe that to be the case.
I understand.
So how would that even come into play? Mr. Bennett, how does that even come into play?
I explained what my position is. I don't know what else to say.
Okay, let me just say this. I don't care if somebody's on the defense. I don't care if somebody's on the prosecution side. It doesn't matter to me, especially between counts. No one is ever going to come into this courtroom and be intimidated in some way by some threat to their profession, particularly.
Here it comes. The judge is about to deliver one of the most powerful judicial smackdowns I've ever witnessed. Notice the tone shift. This isn't just disapproval. This is genuine anger. When a judge says, "I don't care what side you're on," you know someone's about to get absolutely destroyed. This judge is making it crystal clear that using professional threats as a litigation tactic is completely unacceptable. What Bennett did wasn't just unethical. It was an attack on the entire justice system. Using grievances as weapons undermines the integrity of the legal profession and creates a toxic environment where attorneys are afraid to do their jobs. This is about to get brutal.
Particularly in proceeding with what is their obligation. It is Ms. Hughes's obligation to bring this case. It is your obligation to defend your client. She can't make threats to you to try to prevent you from proceeding to defend your client, or to do nothing if your client wishes that for you to do that as the defendant. That behavior, Mr. Bennett, is inexcusable in this court's mind. Absolutely inexcusable. And quite frankly, sanctionable. Because you can't try to make somebody not do something by, quite frankly, as I'm listening to your explanation, are just absolutely unequivocally false threats to their livelihood.
Absolutely unequivocally false threats to their livelihood. The judge just called Bennett a liar to his face. And notice the word sanctionable. That means Bennett could face fines, suspension, or worse. This isn't just a stern talking to. This is a judge signaling that Bennett's own career is now in jeopardy. The irony is incredible. Bennett threatened to grieve the prosecutor, and now he's the one facing potential sanctions. This is what we call instant karma in the legal world. But watch what happens next. Bennett's about to try the weakest defense I've ever heard.
I don't believe that's what I was doing.
What do you think you were doing?
Trying to bring to Ms. Hughes' attention an issue that may or may not exist. She interpreted it as a threat, which I understand.
I'm going to grieve your boss. And you.
I did not.
If you start this exam. She's supposed to take that as something that should be brought to her attention as opposed to a threat?
We continued our discussion a second time where I was explaining where I was coming from. I did not say what I said in a very artful way. So
You threatened a grievance for her proceeding. Am I wrong in that?
I didn't consider that I threatened it. I was trying to bring an issue forward. She took this threat.
She took it as a threat. What was she supposed to take it as?
She took it how she took it. I mean, it was a mistake on my part. I acknowledge that.
You're trying to tell this court that you didn't intend to threaten her boss and ultimately her? Is that what you're telling me, Mr. Bennett?
I was trying to bring the nature of what I saw as a potential issue. I unfortunately started it.
The issue being what? Their use of evidence pursuant to the court rule, which is why we have these hearings, why you have the ability to object, and then this court would have to rule.
I felt this case was different because this is not a situation where the alleged victim is given another detailed statement as to what happened.
And so what makes that different?
The duty to investigate the facts.
How do you know they haven't?
Besides her telling me that they haven't, I don't know.
I don't know who her is, but I've never told him the information. I've never told him about the many contacts that she's had with my office. I've never told him about, he's put on the record that she's been appearing at the hearings. Your Honor, she's been at hearings that Your Honor has presided over. The letter that was turned over to the police department was then turned over to the defense. And frankly, he has never asked me. He just came forward with, I'm going to grieve Ellie Sabat.
Mr. Bennett, I am very concerned. What was your intent on saying that?
I intend in the.
You know, I'm going to stop you right now because I'm going to tell you something. You need to be real careful because I may have to consider grieving you.
Oh my God, the tables have completely turned. The judge just threatened to grieve Bennett. This is the ultimate Uno reverse card. The attorney who tried to weaponize the grievance process is now facing the exact same threat, but this time it's legitimate. When a judge warns you to be real careful and mentions grieving you, your legal career is hanging by a thread. Bennett went from predator to prey in less than 14 minutes. The judge is giving him one last chance to explain himself, but honestly, there's no good explanation for what he did. This is career suicide playing out in real time.
I understand that, you know.
And I don't think you want that.
I certainly don't want that.
So what I'm going to do is I'm going to take another about 10-minute break. And I'm going to come out and ask for your explanation before I decide on anything that I would do. But I will let you know, Mr. Bennett, with regard to what I've heard of the conduct here, you are walking on real thin ice, not just with me, but with your ticket to practice. Court's in recess. All rise. Back on the record in case of the people State of Michigan versus Whitley. Counsel is present as well as the defendant. Is there anything else regarding this issue that either side would like to say?
Your Honor, I'm going to self-report the violation under Michigan Rule of Professional Conduct, subsection A. I agree that I gave the inappropriate message to the prosecutor. I apologize for doing that. I feel obligated to report myself.
And there it is, complete capitulation. Bennett just announced he's going to self-report to the Bar for Professional Misconduct. Do you understand how rare this is? Attorneys almost never voluntarily report themselves because it's basically career suicide. But Bennett knows he's cornered. If he doesn't self-report, the judge definitely will, and it looks much worse when a judge files a complaint. This is damage control at its finest, but it might be too little, too late. Self-reporting doesn't mean you avoid consequences. It just means you're admitting guilt up front. Bennett's legal career might never recover from this moment. What do you think? Is self-reporting enough, or should he face the maximum penalty?
For myself.
We will see if that happens because the court hasn't made a decision as to whether or not the court should report you. Mr. Bennett, I am going to tell you in all the years I've been here, counsel, and even when I was down in the trenches, counsels say things to each other, maybe not meaningful. Necessarily, they'll say things out of anger to each other. I don't know why you would even think it would be within the bounds of anything decent to make that kind of threat. And I call it a threat. That's precisely what you were doing. And I have to make a decision now knowing it as to whether or not I should do it. And I will make that decision. Ms. Hughes, and I'm going to apologize on behalf of the court for having to do this, but I think it's necessary given this turn of events. Would your lay witness, as well as I guess the officers, would they be available on July 1st at 10?
Is it at all possible to have the lay witness testify? It would be to identification, and I would...
As to identification of...
the defendant. So it's very brief, and I don't want to have to bring the lay person back.
Understand. Mr. Bennett.
I would stipulate to the identification.
So you're stipulating that the person that is sitting beside you is James Whitley and that he was in a relationship with Jennifer Potter on April 27th, 2024.
Yes.
Thank you.
Will that satisfy what that witness would testify to?
Yes.
Very good. Thank you.
What was the date? I apologize.
I am going to adjourn this, if it will work for everybody, to July 1st at 10 a.m. That is my only.
July 1st at 10 a.m.
I realize that gets close to a holiday, but will that work for?
Yes. Thank you.
Oh, that's fine. I will adjourn it. Mr. Bennett, please apprise this office as well as the prosecutor if you're going to self-report so that maybe others of us don't have to take any action.
Yes, Your Honor.
Preliminary examination in this matter is adjourned.
Let's break down what we just witnessed. Defense attorney Bennett attempted to intimidate Prosecutor Hughes by threatening to file a grievance against her and her boss as she proceeded with the preliminary examination in the case of Michigan versus James Whitley. The judge immediately recognized this as attempted obstruction of justice and potential grounds for sanctions. Bennett's justification, that the prosecutor hadn't properly investigated because the victim recanted, fell apart when he admitted he didn't even know they had a lay witness ready to testify. The judge delivered a scathing rebuke, calling Bennett's behavior inexcusable and sanctionable, and even threatened to file a grievance against Bennett himself. Ultimately, Bennett was forced to apologize and announce he would self-report to the bar for professional misconduct. The hearing was adjourned to July 1st, with Bennett's career hanging in the balance. This case perfectly illustrates why using professional threats as litigation tactics is not just unethical, it's career-ending. If you found this legal breakdown as shocking as we did, make sure to smash that like button. Drop your thoughts in the comments below. Do you think Bennett should lose his license? And don't forget to subscribe and hit the notification bell for more jaw-dropping courtroom breakdowns where justice is served hot